whether legitimate, natural, or adopted, or where the accessory is a relative by affinity within the same degree, unless the accessory himself profited from the effects or proceeds of the crime or assisted the offender to profit thereon. PD 1829 penalizes the act of any person who knowingly or willfully obstructs, impedes, frustrates or delays the apprehension of suspects and the investigation and prosecution of criminal cases. Note: the benefit of the above-mentioned exception in Article 20 of the RPC does not apply to PD 1829. Abandonment. Abandonment. Voluntary relinquishment of an office by the holder with the intention of terminating his possession and control. Species of resignation. Resignation is formal relinquishment. Abandonment is voluntary relinquishment through non-user. Non-user neglect to use a privilege or a right to exercise an easement or an office. A person holding an office may abandon such office. Non-user. Acquiescence. Non-performance does not constitute abandonment when temporary disability, involuntary failure to perform, public officer vacates office in deference to the requirements of a statute which is afterwards declared unconstitutional, such surrender will not be deemed abandonment. Mere delay in qualifying for an office is not abandonment, but failure to assume office in 6 months through proclamation, without just or valid cause, shall have the effect of vacating the office. Automatically separated if he fails to return to the service after the expiration of 1 year leave of absence without pay. Absent for at least 30 days without approved leave are considered an absence without pay, AWOL, and shall be dropped from the service after due notice. Granting or approval of leaves discretionary on the head and depends upon the needs of the service. Failure to make courtesy call to one's superior is not an offense, much less a ground to terminate employment. Article 282, Labor Code, Analogous Causes of. Powered by Jack Skipp's Outlook. Purpose: to solve how to terminate employment through just causes provided by law. Control and chronology. 1. Obesity equals a set reasonable qualifying standard. Prescribed weight equals E failure to meet standard prior to be hired, and after being hired, to keep his position, equals not require that the failure to meet be willful or intentional. 2. Gross inefficiency equals E's failure to observe reasonable prescribed standard of work or to fulfill reasonable work assignment equals due to inefficiency. 3. Positive use of dangerous drugs. 4. Abandonment equals see separate comment. 5. Instigating labor unrest. 6. Fighting with supervisor or superior. 7. Immorality in case it is required as a standard by the like in the case of teacher. Totality rule, add in all previous infractions. Cogitive offense rule, add in previous infractions not related to each other, if combined not related considered double punishment not legal. 1. Termination by employer. An employer may terminate an employment for any of the following causes. A. Serious misconduct or willful disobedience by the employee of the lawful orders of his employer or representative in connection with his work. B. Gross and habitual neglect by the employee of his duties. C. Fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. D. Commission of a crime or offense by the employee against the person of his employer or any immediate member of his family or his duly authorized representatives, and E. Other causes analogous to the foregoing. See Section 36, RA 9165, Drug Test. 2. Other causes analogous equals the obesity of employee is a ground for dismissal. A. Standard violated. Weight equals crew maintained to keep his position. T. He stands standards violated in this case were not mere orders of the employer, they were the prescribed weights that a cabin crew must maintain in order to qualify for and keep his or her position in the company. In other words, they were standards that establish continuing qualifications for an employee's position. The failure to maintain these standards does not fall under Article 282A, whose express terms require the element of willfulness in order to be a ground for dismissal. C. Failure to meet the ERS qualifying standard falls under the other causes analogous to the foregoing. The failure to meet the employer's qualifying standards is in fact a ground that does not squarely fall under grounds A to D, and is therefore one that falls under Article 282E, the other causes analogous to the foregoing. D. Qualifying standard equals norms apply prior and after EE is hired. By its nature, these qualifying standards are norms that apply prior to and after an employee is hired. They apply prior to employment because these are the standards a job applicant must initially meet in order to be hired. They apply after hiring because an employee must continue to meet these standards while on the job in order to keep his job. E. Ground for dismissal equals EE failure to meet qualifying standard of equals not require that the failure to meet be willful or intentional. Under this perspective, a violation is not one of the faults for which an employee can be dismissed pursuant to Pass A to D of Article 282. The employee can be dismissed simply because he no longer qualifies for his job irrespective of whether or not the failure to qualify was willful or intentional. 3. The dismissal of petitioner can be predicated on the bona fide occupational qualification. A. Employment in particular jobs may not be limited to persons of a particular sex, religion, or national origin unless the employer can show that sex, religion, or national origin is an actual qualification for performing the job. B. Qualification is called bona fide occupational qualification. The qualification is called a bona fide occupational qualification, BFOQ. C. The test of reasonableness of the company policy is used because it is parallel to BFOQ. BFOQ is valid provided it reflects an inherent quality reasonably necessary for satisfactory job performance. D. Safety of passengers equals cabin attendant maintain agility at all times plus strict requirement being comprehended. Primary objective of PAM in the imposition of the weight standards for cabin crew is flight safety. It cannot be gainsaid that cabin attendants must maintain agility at all times in order to inspire passenger confidence on their ability to care for the passengers when something goes wrong. It is not far-fetched to say that airline companies, just like all common carriers, thrive due to public confidence on their safety records. People, especially the riding public, expect no less than that airline companies transport their passengers to their respective destinations safely and soundly. A lesser performance is unacceptable. 4. Meaning of gross inefficiency. International School Manila versus International School Alliance of Educators. A. On gross inefficiency, we ruled in Lim v. National Labor Relations Commission that B. Gross inefficiency falls within purview of other causes analogous to foregoing equals constitute just cause to terminate EE. G. Gross inefficiency falls within the purview of other causes analogous to the foregoing, and constitutes, therefore, just cause to terminate an employee under Article 282 of the Labor Code. C. Analogous to other grounds provided by Labor Code, one is analogous to another if it is susceptible of comparison with the latter either in general or in some specific detail, or has a close relationship with the latter. D. Gross inefficiency closely related to gross neglect equals both involve specific acts or omission of EE plus resulting damage to a Gross inefficiency is closely related to gross neglect, for both involve specific acts of omission on the part of the employee resulting in damage to the employer or to his business. E. Failure to observe prescribed standards of work or fulfill work assignment due to inefficiency equals constitute just cause for dismissal, in vice versus Laguindingan. This court ruled that failure to observe prescribed standards of work, or to fulfill reasonable work assignments due to inefficiency may constitute just cause for dismissal. 5. Reasonable standard. A. The court enunciated in PV National Labor Relations Commission to set high standards of efficiency for its teachers since quality education is a mandate of the Constitution. B. Reasonable standard and not arbitrary. Courts are not at liberty to set them aside. C. School determine whether standard met equals is in accordance with academic freedom. Moreover, the prerogative of a school to provide standards for its teachers and to determine whether these standards have been met is in accordance with academic freedom, which gives the educational institution the right to choose who should teach. D. As held in Agabo v. National Labor Relations Commission. I. Has obligation to pay just compensation. To observe due process, the law imposes many obligations on the employer such as providing just compensation to workers, observance of the procedural requirements of notice and hearing in the termination of employment. 2. Has right to expect from EE not only good performance but also good conduct and loyalty. On the other hand, the law also recognizes the right of the employer to expect from its workers not only good performance, adequate work and diligence, but also good conduct and loyalty. The employer may not be compelled to continue to employ such persons whose continuance in the service will patently be inimical to his interests. 6. Section 36, RA 9165, Dangerous Drug Code. Positive use of dangerous drugs. A. EE found positive use of dangerous drugs equals ground for suspension or termination employment. Any officer or employee found positive for use of dangerous drugs shall be dealt with administratively, which shall be a ground for suspension or termination, subject to the provisions of Article 282 of the Labor Code and pertinent provisions of the Civil Service Law. Article 283, Labor Code, Abandonment. Powered by Jack Skip's Outlook. Purpose: to solve how to terminate an employee due to abandonment. Control and chronology. Abandonment: failure to work without valid reason plus clear intention sever a /EE relationship. EE file illegal dismissal with prayer for reinstatement. Proof of desire to return to work negating a charge of abandonment. The two elements which must concur for a valid abandonment, viz. 1. Failure to work without valid or justifiable reason. The failure to report to work or absence without valid or justifiable reason, and 2. Clear intention to sever a /EE relationship, a clear intention to sever the employer-employee relationship, with the second element as the more determinative factor being manifested by some overt acts. A nature of abandonment. 1. Meaning abandonment. A. Abandonment equals unjustified refusal perform duties. Abandonment as a just ground for dismissal requires the deliberate, unjustified refusal of the employee to perform his employment responsibilities. Mere absence or failure to work, even after notice to return, is not tantamount to abandonment. B. EE file illegal dismissal with prayer for reinstatement equals proof of desire to return to work negating a charge of abandonment. Furthermore, it is well settled that the filing by an employee of a